We're now coming on to the new RTA protocol. I'm going to give you a little bit of background to it. You can trace the origins to a Ministry of Justice consultation. I don't particularly recommend reading it. It doesn't say much which we don't already know. And then it's fleshed out in a document called the Low Value Personal Injury Claims in Road Traffic Accidents. And that document is essentially a list of the things that the government want to do in a discursive form, and they have now been put into draft rules. The consultation, the government consultation which decided that there should be a new protocol, was a consultation mainly on the track limits, the limit for the small claims track and the fast track. And this was said to be a response to a report by the Better Regulation Task Force, whoever they are. It was actually a team assisting Tony Blair's red tape czar, David Arunculus, a former BBC producer turned media company director. And his signature appears on the report, and he was mandated to cut red tape by 25%. The Better Regulation Task Force disappeared and was replaced by the Better Regulation Commission, and after a couple of years that was closed, and now there's a Better Regulation Executive. So we've got a whirlwind of new regulations. We seem to have a whirlwind of new regulators and also a whirlwind of the people who are checking up on the regulators, changing their identity every couple of years. There we are. The great problem is that every set of regulations creates problems and side effects that nobody had foreseen, or not the government hadn't foreseen in any event. The government response is usually to produce yet more complex regulations, which it seems to have been just exactly what happened here. Sometimes people see sense and repeal the regulations entirely, which of course happened with the CFA regulations in 2005, which have created so much satellite litigation. Better Regulations Task Force website is no longer functional. You can still get the document online from a government archive. There are several recommendations in it. It proposed new regulation of the claims management industry, which of course has happened, opened the way for contingency fees, which is happening maybe to some extent anyway. It led to a statute called the Redress Act 2006, the Redress Act, which nobody seems to want to implement. Implementation is in fact recommended by the Jackson Report on Civil Costs, whose final version was published quite recently. What the Redress Act does is allow the NHS Litigation Authority to set up an alternative procedure to litigation for complaints where there may be an element of pecuniary compensation up to £20,000. And in fact, in March, last month now, in March 2010, Lord Tebbit asked in the House of Lords how the government were getting on with implementing it, and the answer was basically not at all. It was pointed out that the Jackson Report has recommended its implementation. Parliament at the Select Committee on Health is interested in it, so it's still on the radar. But at the moment, there are no draft rules, as far as certainly no published draft rules, and no immediate plans to implement this scheme for medical complaints. And then coming on to the new RTA regime, which was also recommended quite briefly in this Better Routes to Redress document. It said that the protocol should require parties to provide an explanation of why they had rejected mediation or rehabilitation as a means of resolving a dispute. I don't quite follow how you can reject rehabilitation as a means of resolving the dispute, but there we are. That's what they say. And the judge should consider this when deciding on costs. So the red tape czar, who was mandated to cut red tape, has lit the touch paper, so to speak, on these very complex new regulations, new rules in CPR and the new pre-action protocol. The original report is rather a strange document. There's almost no research in it, apart from a long list of media sound bites about compensation culture, combined with a statement that the authors couldn't find anybody who believed there was a compensation culture when they spoke to them. There's actually a chapter called Compensation Culture, It's All in the Mind. And that's really all the report has in it.